Good morning, everybody. Good morning. My name is Rob Schenk. I'm neither Andy Ebon or Alan Berg. I missed the memo that I'm supposed to grow my goatee out. So I wanted today to go find both of them and let's take a selfie of all three of us, but the light would probably blind the camera, right? So if you're here for Loopholes, you're in the right place. I'm going to do this kind of like an improv thing because the loopholes that I want to talk to you about might change by the time that I did this presentation and gave it to Shannon to today. So if you want more information about what I'm going to talk about, shoot me an email because the slides are not going to give you very much information. They're actually kind of stupid slides. But let's start. All right. This interesting gentleman is Professor Neil Kimcoff. He was my civil procedure professor in law school, and he said this Yoda-like phrase to us first day of school. He said, "There are no technicalities, there are no loopholes, there is only the law." And that basically means that whatever happens, whatever court decision there is, whatever statute gets passed, there's no sneaky thing behind it. There's going to be a public policy that's going to be enforced and a public value that's going to be enforced no matter what the outcome is. So whether it's good or bad, somebody somewhere down the line said, we as a public will benefit from the outcome of this law or this statute. All right? So that puts the damper on the sneaky tricks and stuff like that. But that was the first Yoda-like thing we learned in law school, is that there's just the law. So real quickly, disclaimer. I, unfortunately, am not your attorney yet. You guys show me the green. And this is for general informational purposes only, okay? If you've seen me before, you're getting the same spiel. So let's get started. Okay, in the wedding and event industry, breach of contract actions against wedding vendors are one of the most prevalent forms of lawsuits, okay? And in a breach of contract action, an angry bride is going to try to get as much money out of you as possible, okay? The law is going to provide them with compensatory damages, meaning damages that flow reasonably from the breach. So for example, if you're a wedding photographer and you miss, let's say, the last hour, the bride is going to sue and be able to get whatever value that last hour is. Or if you're a DJ and you miss the last hour, if you're a florist and you don't give all the bridal bouquet or the bridesmaids bouquets, they're going to try to quantify that as best they can, right? Sneaky lawyers like me are going to try to get more damages than that. So one of the key loopholes, one of the key contractual provisions that you want to consider having is called a limited liability clause, okay? And again, you can email me and be like, Rob, point me in the direction of one of your blog posts about limited liability, and I'll do that because I don't have the slide up here. Limited liability basically says, no matter what lawsuit you try to get against me, whatever lawsuit you bring against me or my company, the damages that you are going to be able to receive from me, whether I did it or not, whether I'm liable or not, the most amount of damages that you're going to be able to get from me are limited to the amount of money that you paid for the contract. The amount of money that you would be able to get from me in a lawsuit is limited to the amount of money that you paid me to do this contract. Does that make sense? So let's say that the contract value is $5,000. If you heinously mess up or don't show up and they try to tack on in a lawsuit, emotional distress, pain and suffering and things like that, whether or not it's justified, the amount of money that that court is going to be able to award is $5,000, okay? So the public policy behind that, the Neil Kimcoff reason, is because we as business owners should be able to contract that type of damage so that we as business owners know what kind of risk we have. Understanding the pain and suffering damages is difficult moving forward. It's a difficult risk analysis to do if I sit down, particularly in the event industry when things are supposed to be once in a lifetime. So you're telling that bride that this is not going to be something where if I mess up, you're going to be devastated for 6 years, right? We're talking about this is $5,000. This is just the same as if I was selling you a truck and I messed the truck up. It's whatever the value of the truck is. Does that make sense? You're bridging from the unknown damages of pain and suffering down to this is the contractual damages and this is it, okay? Okay, second thing. In the American judicial system, for the most part, everybody has to pay their own way. They have to pay their own legal fees and their own court costs. That's just how we do. There are some statutes that will shift that to where the losing party has to pay. So, for example, if you register a copyright in a photograph and somebody infringes on that and you sue and are successful, you can get attorney's fees as well as damages that would naturally flow from that. Those are going to be some statutory exceptions to the rule that everybody pays their own way. However, public policy allows business owners to contract against that general rule that everybody pays their own way. So a clause that you might consider is basically an attorney's fees clause that basically says something along the lines of, if I've got to chase you for money, you are going to have to pay my reasonable attorney's fees. Does that make sense? We're contracting around the general rule that everybody's got to pay their own way. That's one of the most asked questions that I get. It's like, Rob, if we sue this punk, can I get attorney's fees because I don't want to have to pay for you? And I'm like, no. Only in really egregious circumstances where there's statute supports that you can't do it. However, when I see that contract and I'm reviewing it and I'm letting that person know if I can represent them, if I see that clause in there, it's probably going to be good to go, right? Legal fees, attorney's fees, making sure that you're shifting. If I'm successful in a lawsuit against you to have to do X, Y, and Z, most of the time it's chase money, you're going to have to pay my attorney's fees. All right? Okay. Next thing is venue policies. Okay? If you're a venue owner right now, you can just basically check out because this is for everybody else. So, do you guys remember, I think it was last year, where a videographer was behind the altar as the vows were being given, and the preacher, the reverend, or whatever he was, turned around and said, if you guys do not get out of here, I'm going to shut this thing down, right? Okay, so you know what I'm talking about then. So what would have happened if I think they did actually stop. So what happens if the bride were to say, you know what, I wanted that shot from behind the altar of our vows and you didn't get it, so I'm going to sue you for breach of contract, right? And you as the videographer are like, well, man, the guy was going to shut this thing down. What am I supposed to do, right? So what you can have in your contract is have the client agree that you are going to be obligated to adhere to the policies and guidelines of the venue itself. And it's not just crazy priest guy. It can be, load-in times. It can be how late you can play your music real loud, right? It can be whether or not you can tack things on the wall, right? So what you're saying is that you have to do what you're told from the venue. And so any breach of contract action is not going to work because I can only do what I'm allowed to do. Does that make sense? So in that context, I'm going to file a motion to dismiss if you get sued. It says no, like we had to do what we were supposed to do. And I see that more and more, particularly with DJs. So you're going to get an extra loophole. Let's talk about a non-disparagement clause, okay? And this is kind of like a Jerry Springer final thoughts, okay? This has been bubbling up for the past 6 or 7 months. I've been hearing more and more about hotels, photographers, dentists, talking about putting non-disparagement clauses in their actual contract itself, okay? Saying, look, agreeing at the outset that you are not going to be able to give me a bad review. Is everybody familiar with these things? Like, you haven't heard about that? No review clauses. So when your bride comes to you and signs the contract, in your contract it says you agree not to give me a bad review, okay? There is a question of whether or not those are going to be enforceable, okay? That's a very new thing in the law. And there are several cases right now that are going on in different states, and we don't know what the outcome is going to be because generally how it works in the law is that it has to be litigated at the trial level of whether or not these things are enforceable. It gets appealed and goes up on appeal, and that's when we learn the courts make those decisions, and we can use those as guidelines of whether or not they are enforceable. And right now, there's really not any guidance on that. So I can't tell you whether or not that's a good idea in terms of whether or not it's going to be enforceable under the law, but I do want to tell you that as a business owner, as an attorney, I advise clients and brides to run away when they see that. I do not think it's a good idea to contract for silence at the time that the contract is signed and executed. I like non-disparagement agreements at the time that there's a dispute. I want me as a business owner to stand by my reputation. Does that make sense? So from a policy standpoint, I like standing by the guarantee that I'm going to do a good job and I'm not going to contract around you giving me a bad review. If I deserve it, I'm going to get it, right? Okay, so that was my Jerry Springer final thought on that. Email me if you want blog information about what the 3 clauses that I talked about. And thank you very much. It's been fantastic.